Really close to the point.
Okay, I think we should get started. It's quarter after, and we have a exciting program this afternoon. And first of all, thank you everyone for joining us. I think we have a very diverse crowd of some of our students and community members and faculty member and staff and also some of the guests. So just want to take this opportunity to welcome everyone. And this is really a great occasion that we get to host this event. And also have our partner of this event with us. And so this is, as you know, that we're having this gathering, this luncheon together to learn about the civil litigation reform. And I just want to start by thanking our partner in this effort, Francis Greenberger, and the Greenberger Center for Justice. And you will soon learn from our panelists. And as you see that we have 5 panelists, including 2 of them are moderators. And these are significant. There are some significant obstacles of having one's day in court. And after sustaining a financial loss or physical injury and what have you in a non-criminal matter, and these obstacles to justice exists, whether someone can afford an attorney or not, and these issues seem to be getting worse and worse all the time. And so this is one of the issues that the Greenberger Center for Justice has been trying to address for quite some time. And thank you to our panelists and Leah Nichols, who is the Director of Access to Justice Project at the Public Justice. And Leah is with us today, and Mark Kuker, who is a nationally recognized environmental litigator. And thank you for joining us here as panelists. And then, of course, as a distinguished Baruch alumnus and a supporter, I also want to extend a special thank you for our third panelist, Francis Greenberger. And thank you for our moderator, Baruch professors, Valerie Wagnick, chair of the Department of Law and the Executive School of Business, and a Baruch professor, Robert Wagner, who is the deputy chair of the same department. And I appreciate the time that you have devoted to today's program. And this is truly a collaboration between the Department of Law and at the Executive School and the Greenberger Center for Justice. And finally, thank you for the team from the Greenberger Center, including Jill Turner, Damon Rao, and Executive Director Cheryl Roberts, and for their efforts. I'm looking forward to this program, and we'll now turn it over to Damon Rao, the Managing Director of Operations at the Greenberger Center.
Good afternoon. My name is Damon Rome, the Managing Director of Operations at the Greenberger Center for Justice. Unfortunately, our Executive Director, Cheryl Roberts, was unable to attend. So on behalf of Cheryl, Francis, and all of us at the Greenberger Center, I want to welcome you to today's program and thank you for attending. Thank you, President Wu, for your opening remarks and partnering with the center on this important program. Thanks to Professor Valerie Watnick and Professor Robert Wagner for your collaboration and partnership and for moderating the program. The Greenberger Center is proud to be partnering with Baruch College to help educate the public about the obstacles to having their day in court. As we will hear, the lack of access to justice impacts people from all walks of life and across a range of issues. Some are prevented from getting repaid when a defective product breaks or causes harm. Others are left paying to fix a problem when a contractor or architect makes a mistake. And others who develop cancer or other diseases due to the improper disposal of toxic waste can never be fully compensated, often have little chance of stopping a polluter from harming others, at least not without Herculean efforts. Unfortunately, the obstacles to seeking justice are getting bigger. Today, you'll hear from our panelists about the struggles they or their clients have faced in accessing justice. But you'll also hear about some of the efforts organizations like Public Justice are engaging in to level the playing field. We hope you've gotten something to eat, as I will be shortly turning the program over to Professor Watnick and Professor Wagner. We also hope you'll stay around after the program to network with our panelists. To give you a little bit of background information on the panel, Valerie Watnick is a professor and chair of the Department of Law at Baruch College Zicklin School of Business. Professor Watnick has written multiple law review articles on the regulation of toxic substances and the regulation of pesticides. Robert Wagner is an associate professor and deputy chair of the Department of Law. He has written numerous articles on corporations, suits against corporations, and criminal and securities law. Mark Kuker is one of the nation's foremost environmental litigation attorneys. Mark has represented hundreds of citizen groups in his lengthy career, including in Toms River, New Jersey, home to one of the country's most notorious Superfund sites and the subject of the Pulitzer Prize-winning book, Toms River, Story of Science and Salvation, which referred to and featured Mark's work. Leah Nichols is the director of Public Justice's Access to Justice project, which focuses on ensuring the civil court system is an equitable tool for justice instead of an obstacle. Leah has briefed, argued, and won cases in state, federal, and appellate courts across the country and spoken at numerous national conferences on topics such as arbitration, class certification, standing, court secrecy, preemption, and consumer protection. And Francis Greenberger is the founder and president of the Greenberger Center for Justice. He's also an active board member of numerous art and educational organizations like Art OMI, New York Edge, and the Baruch Advisory Council. In his for-profit life, he is the CEO and chairman of Time Equities, Inc., a multinational real estate company, and Sanford J. Greenberger and Associates, a literary agency. Please welcome our panel.
Microphones on. Please. So, right, start your engines. Welcome, everyone. Thank you so much for being here today. I have a series of questions we'll go through. We'll ask each of our panelists, and we'll have 2 rounds of questions, and then we'll have time for audience questions afterward. Leah, we want to start with you. Can you introduce us to the Access to Justice project, and what specific gaps in the legal system was it designed to address?
Sure. Thanks so much, Valerie. So the Access to Justice project at Public Justice, as the bio said, we work to make sure that the civil court system is an equitable tool for justice. And so what does that mean? That it is actually a place where people, particularly people with less power, can hold the more powerful accountable. And we work to dismantle the obstacles to the civil court system doing that. One of the first obstacles is the ability to actually get into court in the first place. And so we work on things that some people might call procedural. But as the saying goes, if you write the substantive rules and I write the procedural rules, I'll win every time, right? So it's about making sure that people, particularly ordinary people or small businesses, can actually get to court. So what we do, for example, is work to battle forced arbitration. So you sign a cell phone contract, maybe a credit card. It's going to have a provision, most likely a provision in it that says, if there's a dispute between us, you can't go to court. You have to go to arbitration, which is sort of like a private court system that turns out doesn't work very well. And it also turns out, we can talk more about this, that arbitration clauses are used mostly as claim suppression in this context. So there's that. We deal with standing. So under the US Constitution, Article 3 says you have to have a case or controversy to bring a claim in federal court. That's been interpreted by the US Supreme Court to mean all kinds of things and impose all of these requirements. And so we are working to try to limit those requirements as much as we can so that more people can get into court and bring their claims. We work on fighting off federal preemption of state law. So if you have a state law claim, that you can actually bring that state law claim instead of them saying, hey, there's a federal law that means that, you know, even if this is highly illegal, you under state law, you don't get to bring that claim because of federal law. So those are, there are more things we work on. Those are a few of a flavor of the kinds of things that we work on. And again, the purpose of our project is to really make sure that the civil court system is a tool for justice, much more so in a way that it is today. So that's the core of what we work on.
It's super interesting. And you mentioned arbitration, and probably everyone in this room has signed an arbitration agreement. They may not even have realized that they signed an arbitration agreement. And if you have a claim, that could have real life consequences.
Absolutely.
Yeah.
Absolutely.
Are there other situations that you can think about that are real life consequences for people where they can't get into court? You mentioned standing, you mentioned arbitration. And how would the standing issue come into play for, let's say, a consumer?
Sure. So there are a lot of, let's start with federal statutes, since the standing problem is mostly a federal court problem. There are a bunch of laws that require businesses to do certain things vis-a-vis their consumers. So for example, if you're trying to collect a debt, you're a debt collector, you can't lie to people about what will happen if they don't get the debt, for example. They also can't pretend to be a prosecutor, that kind of thing. So there are all of these consumer statutes that are meant to protect consumers from predatory behavior by companies. And there are other types of statutes. There are, employment statutes, et cetera, et cetera. And what Congress recognized that there are real harms when things like that happen. So let's continue with the example of the debt collector that lies about what will happen if somebody doesn't immediately pay what they owe. That has real harms to people because they may act, they may be, think that they're going to have criminal charges brought against them, which they won't. We have a client we have multiple clients who got letters that said, if you don't immediately pay what you owe, we're going to take your house, which was false. It was not true, either as a matter of policy of the company or what they're allowed to do legally. So what Congress has recognized is that those things can cause real harm, but sometimes it's hard to quantify, right? So you can't say, I received this threatening letter that upended my life, but I don't necessarily can point to something and say, I spent, $500 or I lost $1,000. And so what Congress has said, well, then you get something called statutory damages, which if you can prove that the company did the thing that's illegal, then you automatically get $1,000. So that's what Congress has all these statutes. This also comes up, by the way, in the credit reporting context. So for example, if Equifax or Experian or TransUnion says false things about you in your credit report, that's not great. TransUnion, which is the marquee standing decision, was about people whose credit reports said they were terrorists when they were not. But the Supreme Court said, well, and I'll get into, I'm sort of getting into the gist of why this is bad. You don't have any damages. So there are these statutes that Congress says, if the company violates the law, we understand it can be hard to put a monetary number on how you were injured. So we're going to give you statutory damages and you can sue about it. And frequently these are class actions because they're $500, $1,000 claims. But what the Supreme Court said in this case called TransUnion versus Ramirez, which is about the people who TransUnion falsely said were terrorists on their credit reports, said, well, that's great, but you can't actually bring that suit in federal court unless you can show that you were injured in some concrete way. That is, you have a monetary loss or you have some kind of claim that's like, it's analogous to a claim at common law 200 years ago, which is you're moving the law forward.
That's
right? So the court said, well, that's because the Constitution says there has to be an actual case or controversy. And we've interpreted that to impose all of these requirements, including that you have to show an injury. And it's not good enough just to say that a statute was violated as to me. I received the letter that was false. I had a credit report. My credit report said I was a terrorist when I'm not. And so what has happened is that these consumer claims become really challenging to enforce, because unless you can point to, either, the analogous to a common law, there's lots of litigation about what that means because nobody knows what that means and what the limits are, or you can point to money that you spent. You can't sue under the statute that Congress said you can sue under. So that's a real problem. And that has potential spillovers into other, sorry, this is a very long answer, Valerie.
Word is true.
Thank you, Mark. It has spillovers into other areas as well. I know some folks here are working, doing, looking at environmental law. So far, you can still bring citizen suits under environmental statutes, which say that anybody affected by, say, pollution can bring a suit about it if the company is violating the law in the way that they're polluting. But if you apply TransUnion to that, that starts to look really untenable. And so we're really concerned about the ways in which TransUnion, one, that you can't enforce consumer protection laws anymore in federal court, and two, that there's it's going to spill over into other areas as well. Freedom of Information Act claims, for example, is that also seems very untenable under the reasoning in TransUnion. So we're really worried about this. So that's why the standing issue is a problem.
Yeah, very interesting. So if you don't have actual damages that you can point to, court says can't sue, you don't have standing. So great. Francis?
So, Francis, could you just kind of tell us how you first became aware of the problems with the civil litigation system?
Well, I having been in business for 50 odd years, of course, I've experienced the civil litigation system up close and personal as a businessman. But I think I'm remembering a particular moment in which I sort of had an epiphany about this. Was actually at Claire's graduation. And I don't remember the name of the speaker. This was up in Middlebury, but it was some very erudite person. And they were speaking about the justice resolution or the justice system that the Constitution promises people within our country, within our democracy, and talked about the fact that in many cases it was impeded. Later on, after the ceremony, I was sitting around with my son and another friend of Claire's, and my son had a run-in with some a car repair garage or something. And the friend who was there, who I don't think was American, said, well, why don't you bring a legal claim against the garage? In response to my son's rant. And my son says, there's no justice system in America. That was his response. And so I processed that and then began to think about it both in terms of the experience of average people as well as business people, where, and I'll talk a little bit about that later, but the amounts of resources that litigation involves today is mind-boggling. I'm happy to give some examples an hour later.
Sure.
Just one case that happened to us recently, an architect that we had employed, who was a very decent guy. We were doing a renovation of some buildings. And unfortunately, he has an office that's not in, he has both an office in New York, but he has an office that's actually located in Puerto Rico. And he used that staff to prepare the construction drawings. And I think that they just weren't knowledgeable about New York City, and they relied on the US building code. Well, if you're in New York City, you know that the US building code doesn't apply here, or New York City building code takes precedence. Anyway, he designed it around the wrong building code. And the consequences were very substantial because the architect didn't see it. We had a peer review by an engineering firm. They didn't see it. The project got built, and only when we were just about to sell one of the townhouses that were built did I become aware that this had been defective in its, and we had to tear the whole place apart. Spent $5 or $6 million on the fix of the problem, plus consequential damages because it delayed the project and all the rest. And the architect was a stand-up person, and he admitted the error, so there was no question, and there was insurance. And fault was with the architect, but the engineer who did the peer review also. Anyway, and talk about arbitration, the engineers had an arbitration requirement in their contract. The architects had a civil litigation requirement. So we would have to bring two cases. Anyway, we get a lawyer involved. Seems like a good guy. Went through estimating the cost of the case. He estimates that our legal cost would be $500,000. A lot of money, but we had $5 to $8 million in damages. Well, notwithstanding that the architect admitted the problem, his insurance company did not. And the engineers were busy trying to point fingers at the architect back and forth. The amount of time and litigation that this thing took was unbelievable. And the legal costs ran up to $1.5 million before it was resolved and settled. And we got an award of about $4 million or $4.5 million. So we didn't even get our full damages back. Plus, we had to give 40% of it to the legal costs. And I mean, I could take you through chapter and verse. People on my staff spent a week, one person, a week in EBTs, examinations before trial. I mean, what's that about? Aren't that many questions left in the world? But the insurance company obviously decided to somehow, rather than accepting that their client had made a mistake, just to sort of try to beat us to death or whatever. And I can give you many other similar stories. But, you know, I hate to use the word because people that I don't like sometimes use the word. But one part of our legal system has been weaponized. And it's as much about bludgeoning the opponent as it is about arriving at a just resolution to a dispute.
Absolutely.
So before you had some of these experiences, what would you say your initial assumptions about how the system worked were, and kind of how did these experiences change your understanding? And what were kind of the big surprises to you?
Well, one big surprise was the arbitration, which I thought, you know, probably the way most people think, oh, arbitration is an easier venue which will lead to a speedy resolution.
No.
Guess what? When you talk to litigators now, they say never agree to arbitration.
Absolutely.
The arbitration system has somehow been perverted or whatever into a system that is no longer any way resembles efficiency. And in fact, as I say, some of our litigators have told me, never agree. I'd rather be in state court, which is no picnic, than be in arbitration. So, you know, what I took away from that, and is kind of, now I'm not an attorney, although I did take 4 excellent courses at Baruch when I was here and have a grounding in law as a result, but I'm not an attorney. But as I observed the system as a business person and up close and personal, and you know, this litigation wasn't my only one. The system is not calibrated for efficiency. My simple explanation is it's calibrated for infinite inquiry and infinite justice. Well, that may seem like a nice goal, but it's not affordable. And the result is that justice is denied to 99.9% of the country. And I believe that we have to calibrate the system, recalibrate it, have very limited inquiry and limited court time proportionate to the matter at hand so that it is affordable. And, you know, we do have small claims court. Well, guess what? Small claims court goes up to, I think, $10,000. I mean, a toothbrush is $10,000 today. And if there's a corporate defendant involved, i.e. you're making a claim against a corporation, it's not eligible for small claims court. So we need a better system, is my point of view.
So from your perspective, is the problem one of inefficiency or injustice or both?
It's inefficiency leading to injustice. So because we've calibrated the system in this open-ended way, where we don't limit, I mean, discovery, as I said, I've had people, my staff, spend a week or two, one person, under inquiry from a lawyer in a civil litigation. You know, they could probably say everything they had to say in about 20 minutes. So there have to be limits put on it so that people can, and I think it's in small claims court, there's a concept called substantial justice, I think is the phrase. They're not trying to get infinite justice, just get a decision. So limit the time, applies to both sides, concentrate on the essential facts, make the presentation to the judge or the jury or whoever decides in a finite amount of time and move on with life. At least it's resolved as a decision rather than this system which goes on forever and isn't affordable by anybody.
Thank you.
Thank you. Yeah, that's super interesting. And you also mentioned about arbitration. One thing about arbitration is that litigators definitely don't like it. And one of the reasons is because the arbitrators don't have to follow the law. So you actually never really know what the result's going to be. It's really problematic from,
And you can't appeal it.
and you can't appeal it, right? Yeah. So it's not, it was an idea that was maybe going to make the system more efficient, but it's problematic for sure. Mark, thank you for being here. What is your role as an environmental attorney, and how do you try to help individuals navigate this system?
Okay, well, let me just pick up on something Leah said. Why are courts important? You as an average citizen will never have the same access to the White House as the president of Exxon or the president of Apple. You will never have the same access to your congressmen or senators or to lobby Congress as the president of Exxon or the president of Apple. But if you sue Apple or you sue Exxon, you were supposed to stand in court as their equal and have an equal opportunity to win the case. That's the way the system is supposed to work. What has happened, and this was always true to some extent, but it has gotten much worse over the past few decades, is the rich and powerful use their financial power to make the legal system, I will not call it a justice system, make the legal system as difficult, expensive, protracted as possible, and basically wear you out. So my goal as an attorney, obviously, is to try to get justice for my clients in the face of that. It has become increasingly more challenging over the years for a lot of reasons. But the overriding reason is that due to certain changes in the law, large corporations are able to game the system more effectively and make it that much more difficult.
Thank you. Have you worked on a big case that can give context to your comments? And can you also tell us about how the civil litigation system functioned in that case. Such as a case such as one involving toxic pollution or chemical exposures.
Well, yeah, I mean, I've worked in quite a few of them, and basically, let's start with one premise. This is something, another point Leah made I wanted to follow up on. And this has happened to many clients of mine. You wake up one morning and you learn that your drinking water supply, your private well, where you've lived for 30, hope you lived in for 25, 30 years, is polluted with toxic chemicals, chemicals that cause cancer. And you also realize that you've been drinking that water for 20, 25 years. Your children have been drinking that water. You may have been pregnant and carrying a fetus in utero while drinking that. And you have a very well, I mean, what would your reaction be? You would be extremely upset. You have a very well-founded fear of disease. Guess what? That is not recoverable in virtually any state in the union. Fear of disease, if you don't have a disease, cannot be recovered. So what did the plaintiff's lawyers do? We figured out a workaround. The workaround is called medical monitoring. What's medical monitoring? Okay. And it's not accepted in any state, but it's accepted in a lot of states, Pennsylvania, New Jersey, New York, among them. If you've been exposed to a toxic chemical that significantly increases your risk of a latent disease, the polluter should have to pay for the medical testing that you require that will enable you to have that disease diagnosed earlier and treated more effectively. So that's the workaround, and it's been accepted in a lot of states. The issue then becomes, what kind of expert witness do you need? What does the expert witness have to say? With what degree of scientific certainty? And rules have now come down starting back in 1991, where you can't just have an expert give an opinion. The expert needs to meet certain criteria. Motions are filed. Expert has to testify in advance of trial. The judge gets the first pass as to whether the expert can even be heard by the jury. Cases get thrown out. So that decision alone probably by itself doubled the cost of environmental litigation when there's a medical monitoring claim. But that's the world we live in.
Yeah. I think was there a medical monitoring claim in the PFAS issue in the
Hoosick Falls?
what was it?
Hoosick Falls? The answer is yes. Yeah.
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 In other cases involving PFAS, there have been medical monitoring.
There have been
Yeah.
PFAS, in case you don't know, means perfluoroalkyl substances, also known as forever chemicals. Unfortunately, they're just about everywhere. Everybody has them in their blood to a greater or lesser extent, and they're known to increase the risk of certain types of cancer and other diseases. And PFAS cases routinely make medical monitoring claims, and I have in the PFAS cases I've handled.
Yeah. Class action suits are often used to try to get justice in environmental cases. Can you explain what they are, and are they a useful tool to get justice in a civil court?
There's a lot of misunderstanding about what a class action is and a class action isn't. So I really need to make that very, very clear. In a class action, one or two people serve as representatives of a large group of people. The original concept of class actions was they were brought in securities fraud cases. I bought a share of Facebook stock. They lied to me about the projected earnings of the company. The stock went down. In those situations, it's fairly easy to have a shareholder certified to represent a class. In class actions, the court spends a ton of time deciding, is this a proper class action? You don't even get to the merits. And as you might imagine, the other side fights tooth and nail to say it's not a proper class action, because if it is, they lose the case, those one or two people, they've lost to 5 million. So in the environmental setting, it's hard to have cases certified as class actions because of individual differences. Where did you live? How long did you live there? What was your exposure? Class actions have been allowed for medical monitoring in some cases and for property damage, property devaluation in some cases. But it's very difficult. And for that reason, if I'm representing a community, let's say 200 families have signed up with what we call a mass action. I'm not going to spend 3 years fighting over getting a class certified by the court, knowing there's at least a 40% chance I'm going to lose and not even get to the merits of my case for 3 years. I'll just bring it as a mass action. That's my personal preference. Some lawyers are frankly greedier than I am, bigger than I am, and they swing for the fences. But it is tough to get a class certified in an environmental case. Not impossible, but difficult.
So in the case of a mass action, you would just have the 200 people be plaintiffs, right?
Right. So babe, that's the other thing about class actions, which Leah could probably comment on. In a class action, only the class representative is before the court. That means the class can actually be settled without the permission of all the class reps. You just get a notice sent in the mail. If you ignore the notice, then the settlement can be approved, and sometimes a lousy settlement gets shoved down the throats of a lot of people. In a mass action, everybody's before the court. Everybody has a seat at the table. Everybody has a role to play.
Thank you. Should we ask Leah some questions?
Sure. So Leah, what are some of the most promising reforms you've seen aimed at closing the gap between the civil legal needs of low-income individuals in the U.S. and the resources available to address those needs?
That's a
That's a
great
tough one.
question. That's a tough question. I think in the here's what I'll say, what I do and I don't do, and then I'll preface my question with that. There are a lot of amazing attorneys around the country who are working in legal services organizations, who, for example, their clients have their income limitations on who they can serve. They really focus on that. That is not necessarily my perspective, right? Most of our clients are people who are low income, but not necessarily. So I want to just sort of preface what my perspective on this is. From working in the standing and arbitration context, and I want to actually say something that what Mark said, and we haven't talked a ton about. Francis has talked a little bit about arbitration, but I want to say this, and then I'll get into sort of why it's important. Sorry, this is a very roundabout answer to your question. One of the reasons that companies impose arbitration on consumers, employees, renters, et cetera, is because the Supreme Court has said, even if you can't do it in other contexts, you can use arbitration to prohibit class and collective action claims, mass action claims. You have to go through individually. If you have a small claim, that amounts to claim suppression because you're not going to bring a claim for $500. And so for small value claims, that's claim suppression. That's why it's there. At some point, the folks who represent American Express, et cetera, at conferences started saying this explicitly, that like the reason they put arbitration in there is so that they can put in class and mass action bans so that they can suppress claims. So it's not about trying to take advantages of the efficiencies of arbitration. It's about not having to answer to legal claims at all. So to be very clear, I want to say that. So when I talk about reforms with regard to arbitration and with regard to standing, I'll tell you what we have. Look, it's not great out there, is what I'll start with. It's not great. So I'll tell you what we're doing in terms of standing and where the bright spots are in the arbitration context. So with regard to standing, frankly, to change the sort of what I'm going to call the TransUnion problem after the Supreme Court's decision, which, by the way, changed centuries of law that said if you have a claim under a statute, you can bring the claim. To fix that problem, you're not going to be able to fix that in the federal courts without either amending the Constitution or getting a new Supreme Court. Like those are the only things it's going to completely fix that problem. But what we can do and what we're doing is trying to make sure, one, that if you're in federal court, that we aren't expanding TransUnion to kick out more claims than it should. And two, looking at state courts, because state courts are not bound by Article 3. And so may have different rules about what you can do to get into court in the first place. And so we are focusing on making sure that state courts, and we've had some successes recently, don't adopt and do the same thing that the US Supreme Court did with regard to federal courts, so that you can still bring claims somewhere. In the arbitration space, there have been a number, there's for a long time now, there's been proposed legislation to change the arbitration problem can be fixed legislatively because it comes out of a statute from 1925 called the Federal Arbitration Act, which was originally designed to allow sort of business to business, sophisticated businesses, that if they wanted to bypass the court system and resolve their disputes in private arbitration, that sure, they can do that. But it was never meant to impose arbitration on, particularly sort of the claim suppressive arbitration in the way that it has been on consumers and employees, and all of us. Sometimes I think we forget that we're all consumers. So when we talk about consumers, we're not talking about like people over here. That's us. We're all consumers. Small businesses also, I think, fall in this category. They get it imposed on them by American Express or whoever as well. And so we have seen some legislative successes in that space at the margins. There have been proposed legislation to like undo almost all of it, but they haven't passed. And I think, who knows? I don't even know what's happening. And I'm not a lobbyist. Congress is very difficult to read, particularly at this moment in time. But what we have had are successes, as I said, at the margins. So the Military Lending Act, for example, for the types of lending it covers, you can't impose arbitration on members of the military and their families, which is great. There's legislation that says if you have a sexual harassment or sexual assault claim, you can't impose arbitration and you can't preclude class and mass actions. So that's great. There's some pending legislation about race discrimination claims as well. This is a funny one, actually. There's a carve out for car dealers, which is one of the most hypocritical things that I've seen. But if you are a car dealer at the car company, so Honda, can't impose arbitration on, Smith Honda up the road, who's the car dealership, because the car dealers all went to Congress, who have a lot of power in Congress, by the way, car dealers do, to say, hey, that's super unfair. Arbitration's incredibly unfair. You can't let Honda impose arbitration on us. And Congress said, okay, sure, fine. Of course, what do car dealers do, right? They turn around and impose it on their customers. And that is perfectly fine, unless you're you're in a Military Lending Act situation or something else. But so it's one of the most sort of hypocritical things that really sort of sticks in my craw a little bit about this. But we are seeing some activity at the margins. We've had some recent Supreme Court victories. I worked on a case a couple of years ago called Morgan versus Sundance, which stood for the remarkable proposition that arbitration contracts should be treated just like other contracts and not more enforceable than other contracts, which you'd think would be obvious, but had become non-obvious over time. So there are some ways, we've gotten more types of employees excluded from the federal law. So there are inroads at the margins. I think the major overhaul is still to come.
So some arbitration contracts prohibited.
Yeah,
You mentioned a few.
Yeah.
Very interesting. All right. So Francis, what steps has the Greenberger Center taken to address some of these issues? And what are your plans moving forward? Do you have suggestions that might improve the system? Because you pointed to some issues with the system.
So our plans, which have been brewing, the Greenberger Center historically has been involved with criminal justice and a variety of work that we've done in that area. So civil litigation is a new challenge to us. And we began working on this within the last 2 years. I'm not sure exactly when. But as you've heard a little bit here, even reforms at the margins are hard. And in my view, we need much more fundamental reform. And the steps that I see to getting there are to start conversations like the one we're having today, raise awareness about this issue, not let people take for granted the fact that there is no path to resolving their differences. And, you know, we didn't comment on family courts things, but divorce and all the kind of stuff that can also turn into a very long, difficult, and unaffordable process. So raising awareness and, you know, hopefully there's a lot of the future sitting in this room. So as you go forward in your paths, to remember not to take it for granted, and perhaps to, when you see an effort or when you think about it, to start advocating for change in a better system. And that's the plan. Change is complex. Law is complex. You know, I'm trying to simplify it, but it's not the nature of many lawyers to simplify things. In fact, to some degree, they complicate them. But the system, the change in the system has to come through the legal community, because after all, who created it and who's in charge of it? Virtually, I don't know what percentage of legislators are lawyers, but it's very high. So we have to speak out. We have to say that it's not working, and we have to press for change.
Thank you. Yeah, those are good points. Awareness is very important, right? And other than awareness, what role do you think nonprofits, philanthropy, policy advocacy should play in fixing the system?
Well, it's going to take a lot to move this mountain. I mean, we've heard how hard it is to move minor parts of it. And so it really has to be a coalition. And we're reaching out to attorneys. We're reaching out to not-for-profits of a variety of description. We're trying to create a coalition around it. Years ago, we did this in criminal justice, where we saw a need for change. And, you know, in the end, we had a very, very wide coalition supporting a particular reform that we were working on. You know, every DA in New York, victims' rights, the judiciary, a variety of not-for-profits, all came together. And when we started 10 or 12 years ago, if you asked any elected official to talk about criminal justice reform, you know, they were deaf, because they knew that their polls would go down if they engaged. Sort of halfway through, or maybe 4 or 5 years ago, there was a sea change, and enough voices had been raised about mass incarceration that if you were running for elected office and you didn't offer to discuss reform, you weren't going to get elected. So having lived that journey and seeing that change, I'm hopeful that through efforts like this and by reaching out and creating community around this issue, eventually we'll be able to gather enough force and momentum to bring the matter to the legislative level in which it has to get resolved.
Thank you. Yeah. It reminds me your idea of not having infinite justice, but having a more finite form of justice is sort of what these organizations need to band together to seek, right?
To limit infinite inquiry, I mean, for those of us who have been involved in litigation, I mean, you know, I mean, in litigation, you can spend months sitting in examinations before trials. The amount of money we can spend on expert witnesses we're talking litigation used to be, maybe you could have a commercial litigation for a couple of $100,000. Now, if you're honest, it's millions. And I'm not talking for, a major environmental case or the numbers are just staggering. So by limiting the inquiry, limiting the presentation, presenting the essential facts rather than all the facts in the world, the hope is that we can come to an efficient system that can permit dispute resolution on all levels.
Thank you. I always learned, I was taught in law school that one of the reasons that you have such broad discovery is to make the system more efficient so that then the parties would settle. But the problem has become that the discovery just goes on forever and it becomes so expensive and time consuming that it's a barrier, right? Yeah, to actually getting your money back in a case that you like the one you described, right? Very good. Interesting. Do you have some questions for Mark?
Mark, what reforms do you think we could make that would help make class action lawsuits more effective?
Well, probably none. Because
So
like I said,
hopeful.
I'm wary of the use and abuse of class actions. I mean, you could lower the standard you need to meet for to get a class certified. So I do have some ideas for some reforms that I think would be helpful. I don't know if it's going to be your next question or not.
Yeah, about the environmental
Oh,
litigation
yeah.
reform.
So a couple of things. And I really feel Francis's pain, believe me, because I've been down that route myself. But so in the old days, I've been practicing law for close to 50 years, and I don't want to make it sound like there was ever a golden era where everything was wonderful. That didn't exist. But here's what has changed. Every case now gets a motion to dismiss, and then a motion for what's called summary judgment. So motion to dismiss is, did what you put down on paper, even if it's true, actually state a valid claim? And what happened in the TransUnion case was, no, it didn't, because even though you alleged a violation of statute, you needed to show some personal injury that affected you, and the Constitution doesn't allow it. That case gets knocked out on a motion to dismiss. Then you beat a motion to dismiss, and after discovery is taken, there's what's called a motion for summary judgment, which now, based on the evidence which you've uncovered, is there a case that you could prove before a jury that if the jury believed everything you're saying, could you win it? So summary judgment briefing is voluminous. There's volumes and volumes of depositions. And I can tell you that when I started practicing, these were rare. Motions to dismiss were rare. Motions for summary judgment were rare. Now they are routine. They are routine, every case, because they have the economic power. We have an adversary system, which needs to be, actually, I know everybody here takes it for granted. We have an adversary system which each side is told to zealously represent their client and let the neutral decide it. And that adversary system leads to some ultra zealous advocacy. So ironically, there is one rule in arbitration that the American Arbitration Association has. I don't like the American Arbitration Association, but there's an interesting rule. And the rule is you can't file a motion to dismiss without first getting the arbitrator's permission and showing you have a significant likelihood of success. And, it's interesting. I have some case right now where the arbitrator says, no, I don't need to hear that now. And it might be interesting to try that in courts, where before you put the other side to the burden of responding to a motion to dismiss, responding to a motion for summary judgment, you can at least show that the motion passes the smell test.
Can I ask you a question?
Sure.
Do you think that cuts the other way, in the sense that then you have to not only litigate the motion to dismiss. You have to
have to
litigate
ask.
whether you can bring a motion to dismiss.
Maybe another litigation.
Well, I had, yes, but I mean, basically, I wrote a 4-page letter. I didn't have to I just made a couple points. I didn't, the arbitrator is going to do what the arbitrator does. So,
Right, you can't appeal.
yeah, but, I think the rule is interesting in concept. I only had one experience with it. I think it might be interesting to explore whether that makes sense.
The other thing I'll just sort of add, in thinking about sort of what the incentives are and the problems with certifying a class, there's a case currently pending before the Supreme Court called LabCorp versus Davis, which depending what LabCorp, right, the people who take your blood and test your blood, right, that company, if their argument wins, it's going to be so much worse than it is already. And so basically they're arguing that you essentially have to prove the merits of your case in order to get the class certified. And you have to prove it for every single class member. And you have to prove standing for every single class member, not just the class reps. So it's on the verge of, depending on how that Supreme Court case goes, of becoming much, much worse. And I think rather than going the other way. And I think, it's interesting to see sort of where this push has come from. And there is a real, I think concerted effort by the Chamber of Commerce, which has the ear of the biggest businesses and not small businesses, to make it harder and harder and harder to get anywhere in these lawsuits for plaintiffs. And so it's been interesting observing, because that's where like this is coming from. They start sort of as these, little things, but that's where these efforts are to make it harder and harder and harder to get anywhere in court.
Yeah, I just want to add something about coalitions. And Leah made a very important point. There is a huge divide between big business and small business in this country. Small business gets screwed. I represent hundreds of independent pharmacies. They actually are mobilizing a lot of them. There's an organization called the American Economic Liberties Project, which has picked up on this, and they lobby against. They'd like to see arbitration reform, but the way our society is going, with so much wealth concentrated in so few pockets, small businesses, who they're the engines of economic growth. They give rise to all the new jobs. They will be hurt the most by tariffs. They are a very important constituency that needs to be cultivated. One other thing I wanted to say in terms of another issue. When election time comes around, this issue is never on the radar, almost never on the radar. The only time courts are on the radar is, there's lenient judges letting people out who kill people. It's very hard for people to see themselves as victims. It's very hard for people to see themselves as needing access to justice. People don't think someday I'm going to get ovarian cancer because of a chemical exposure. And frankly, the plaintiff's bar has done a lousy job of trying to educate people about that. The plaintiff's bar, by and large, tries to just grease the palms of legislators, and that only gets you so far. So, public justice does a lot of good work in that area, but there is a tremendous amount of awareness that needs to be raised. If you mention lawsuit, what's the first word that comes to the mind of a lot of people? Frivolous. Well, actually, there's a mountain of data that shows that 80–90% of meritorious cases are never brought. It doesn't mean unmeritorious cases there are unmeritorious cases brought, but the obstacles are already in place that only a small fraction of meritorious cases are brought. And people they think about the McDonald's woman who spilled coffee on herself. They have no concept, and a lot needs to be done in that.
I can talk about that case also,
sure you
like the
can.
facts of that case are not, anyway, that was a PR hit job is what that was.
There's a
Talk
documentary
about the
on that.
truth about that case called Hot Coffee, recommend it. But just to back up, I mean, I think it's the federal judiciary at the behest of defense side lawyers did a study because they were sure that there were all these frivolous class actions being filed. And that was absolutely going to be true. So the Federal Judicial Center, which is completely neutral, did a study and found that just not true. That this sort of wave of frivolous lawsuits that people were bringing was just not a thing that was happening. We've talked about how hard it is to get into court and how hard it is to bring a case. A lawyer is not going to bring a frivolous case. And I think we
Not
have,
on a contingent fee.
not on a
basis,
contingent fee, right?
Which
We-
is the only
yeah.
basis most cases are brought.
Yeah, so I think we haven't talked about how lawyers get paid, but which I think is part of, has to be part of this conversation too, is that most plaintiffs' lawyers are on contingency fee, which means that they don't get paid unless they win or settle, right? If they lose, if they get kicked out on a motion to dismiss or a motion for summary judgment, they just have a loss. They don't get paid for that work. And so the same is not true by and large, same is not true for the defense bar. They're paid by the hour, which changes the incentives for how you litigate the cases pretty dramatically. But because of the contingency fee situation, there are not a lot of incentives to bring frivolous cases because you're never going to get paid unless you think you can extort money or something. But it just isn't a thing that's happening, or is happening so rarely. It shouldn't drive the way that we design our system.
Just.
Oh, I'm sorry.
I'll be quick. Just another example.
We're on
I
the
used-
soapbox
I used to
now.
do a lot of medical malpractice work, and we heard a doctor, all these frivolous lawsuits. Well, there have been studies in the New England Journal of Medicine, in many, many medical journals, where they looked at hospital records and they found so many more instances of malpractice compared to the lawsuits that were actually filed. I think it was like 8-1, something like that. So this is just a myth. I'm sorry. That's all I can say.
So people didn't want to bring them.
Well, a lot of them probably didn't know
Yeah.
the true story of what happened.
Yeah.
But yeah, a lot of people don't want to sue their doctors or hospitals. A lot.
Yeah. Francis, just to follow up on their comments, Leah and Mark's comments about how lawyers get paid. If you don't mind saying, the lawyers in the case that you were describing, how were they getting paid?
Cash. And when they went past the $500,000 that I had agreed to, I think we paid them until about 700,000 or 800,000. And I said, well, wait a minute. And of course, they made the case that they couldn't anticipate the amount of the defendants, blah, blah, blah. And then we entered into an agreement for a 50-50
Oh, okay.
of the remaining amount of hours that they would bill. So between 800,000 and $1.5 million, 700 delta, I paid them 350, and 350 was going to be paid when the case was resolved. I would say that the issue of lawyers working on contingency only applies in certain types of cases. Many cases do not. You go into a divorce hearing and ask your divorce lawyer to work on contingency, you'll hear no. And when they do, they're highly selective because, of course, they're concerned about their actually being successful. And the system is uncertain in terms of its outcomes. I would say in business, contingencies are much rarer.
And so most people are paid, but most times the lawyers are paid by the hour.
Correct. And,
But, yeah.
I don't know whether people in this litigators today in New York, do you know what their fee range is? How much? 600 to 2,000 per hour. Most senior litigators are denominated in thousands, 4 figures, not in 3. And that's for the senior litigator. Then there's the associated litigator. So maybe the senior litigator is getting 1,600. Maybe the associate's getting 1,300. And then, if you have the second year associate, oh, he's a bargain at 600 or 800.
So
The
I always
fees-
tell my students a 15-minute meeting could run like a 2,000, and you got a lot of those, and it adds up
So
really
the
fast.
costs here are unmanageable for virtually any business.
Right. Yeah, it's a problem. Thank you. That's very elucidating. So at this moment and this time in time in the program, we'd like to open the program up to questions, see if the audience members have questions. And if you want to direct your question to a particular panelist, please feel free to do so. Yes. The question is, do judges play a part in the problem, and are they well trained enough to help stem the problem that we've identified? Mark wants to answer.
Well, I'll give you an opinion, not an answer. All right. First of all, there's an old joke. What do you call a lawyer with an IQ of 40? Your Honor. Okay. Now, but seriously,
That's mean.
they are the full spectrum. But here's, I'll try to tell you what the most common problem is, and this is a problem in arbitration also. Too many judges are just baby splitters. You have an adversary system where people have an incentive to take an extreme position, and then rather than decide something decisively, they split the baby. And what has happened, again, over the course of recent decades is that it used to be in the good old days, you didn't want to take an extreme position because you'd lose your credibility with the judge. You'd antagonize the judge, alienate the judge, and then the judge against you. Those days are gone. Okay. I have seen the most ridiculous positions taken in court and in arbitration. And the judges listen to them and give them credence. And instead of finding a midpoint over here, now they find a midpoint over here. So that's what's happening. Is there any amount of training that's going to fix that? I know there are judicial colleges. I don't know what they do, but that's what I would, if I had to identify one problem with the judiciary, and there are many, because you do have judges who are stupid, but I think the problem is baby splitting and not really calling it the right way when you see it the right way.
That's interesting. I've seen that as well. We have other questions. I think that
Yes, I'm gonna speak. So you said that cases are then dismissed, or there's some summary judgment. So just yesterday, you had Judge Mary Rosado rule on the case that the New York City Council had forwarded, which did not want to allow ICE into Rikers.
Into Rutgers?
Rikers, jail.
Rikers Island, where they have incarcerated people. So tell me, often the New York City Council files claims. How do they file a claim and it comes up so quickly? How does that really happen?
Well,
I'd like to know.
I don't know anything about that case, but it was probably for an injunction, and injunctions move very, very quickly because
Oh.
you're asking for immediate relief against irreparable harm. We let them in the Rikers Island. They're going to take people, put them in prison in El Salvador. We're never going to see them again. We need a court order immediately, and you get a temporary restraining order. Those move very, very fast. They have to.
Oh, thank you
But
very
that's-
much.
That's fine.
Yeah. Yeah, and just if I could just sort of add a quick explanation, the idea is that you can't do it while the case is pending. So we see this actually in a lot of the cases against sort of the Trump administration. They get a temporary restraining order and/or what's called a preliminary injunction that says you can't do the thing until we resolve the case. And so that happens very quickly, and then they go through all of the merits of the case, and then they get a permanent.
And let me add one point. I handled one such case in my life. It is very intense, and you put in a lot of hours in a short period of time, and on an hourly basis, it will cost a fortune.
let's hear from a student.
Yeah,
into the mic.
much for your time.
Oh, online,
Sure.
yeah.
I think I can enunciate, but I'll try my best.
People on Zoom want to hear the question.
Yeah, so my name is Daniel Yukolov. I'm currently taking a class with Professor Watnick, so I wanted to extend my thank you for everybody's time. I had the pleasure of speaking with Mark, but I want to pose this question to the entire panel. Could you each recommend a book that has been very influential to your career or your life?
Francis, you want to go first? You want to go third?
Well, I just read John Grisham, who some of you may know, famous American lawyer and novelist. I think he's written 100 bestsellers. Just published his first nonfiction book, which he wrote in conjunction with somebody, a colleague. And it's about, not directly related to the Innocence Project, but essentially covering the question of people who've been convicted primarily of murder, dealing with capital cases, and which were later found to be innocent. And the book is extraordinary in the sense that not only does it talk about the way in which these cases were ultimately found to people have been wrongfully convicted, and that's the whole Innocence Project, which some of you may be familiar with, but it's well known. But the description of the legal system and the police system in a variety of locations around the United States is, to call it distressing would be beyond words.
Wow.
There was one case, I mean, it's not funny. There was one case in which a young girl was murdered. And not only did they falsely incarcerate the person that they thought did it, but they managed to incarcerate 10 other people, all for the same crime. I mean, it's just incredulous. So if you want to raise your concern or awareness of the legal system, I recommend that book, but I have a long list beyond that.
Thank you.
Sure. I got a chance to think while Francis was talking. So thank you for going first. I'll be honest, I don't read a lot of nonfiction outside of my job because I do a lot of reading during the day. But one of the books I read recently that I thought was very well done is The Color of Law, which was about the sort of the way in which government and legally imposed redlining and other sort of has, it's very good. But imposed sort of created the segregation and the systemic racism that we're still fighting today. So I recommend that. One book a fiction book, but one that started as a project of how the incarceration of Black men in particular impacts communities is An American Marriage, which is an excellent book. And it started as I had the fortune of being able to hear the author talk about it after I had read it. And she says, she started with all these statistics and was sort of working from there. And then said, that's not how I want to tell this story. And so tells sort of the story of when people are missing, right? What does that look like? And potentially wrongfully missing. And so in a what is a very well-written novel format. And so I recommend that as well.
Very good. Thank you. Mark, do you have a book?
Actually, the best book I ever read about how the truth gets lost in the civil justice system is A Civil Action, which a lot of you are reading. I had earlier recommended a book called The Shadow Docket by Stephen Vladeck.
Stephen Vladeck is great.
ECK, which will tell you all you need to know. Well, enlighten you about what's going on in the U.S. Supreme Court.
Thank you. A couple people have had their hands up. This lady. Can you repeat the question? Can you try to paraphrase the question for the
I mean,
Zoom?
I guess the question is, I mean this respect, what can be done about an unfair and unjust result? And I think you need to ask your lawyer that question, because judges screw up a lot. I thought, and they screw up sometimes to an unbelievable extent. So, was this a New York City judge? Oh. Usually they have to, well, they can say they don't find it credible even if it's unrefuted. They have discretion.
Well, the thing is too, in the context of, it sounds like you were trying to get a TRO, like in that context, I mean, I don't know anything about New York City and New York State Court. It's not where I practice, but generally like courts have a lot of discretion in that context. Even because not only is it sort of the merits and yeah, look, it's not great. But that is, I think, once you get to sort of the point where you're deciding the final merits, I think things get a little bit different. But in the TRO context, there's a lot of discretion given to judges about whether it's urgent enough, not just, whether you are correct. And that's, again, it's not a great facet of the system, but that would be my sort of initial thought.
Thank you.
Could
We
get
have
a
another question.
From to a guest of mine who's here, Jim Janowitz.
Yeah. Can you speak at that microphone? Would you mind? I'm worried about the Zoom people. Thank you.
One of the culprits, it sounds like, in the problems that we have is the adversarial system, because you have lawyers fighting each other sort of endlessly. I wonder if there's another system, an inquisitorial approach that you would favor in certain circumstances.
I just don't think that's going to happen. I think it's an interesting idea. I think maybe Francis can talk about how the criminal justice system works in other countries, where it's less of an adversarial system, or whether that's also subject to corruption.
Well, it doesn't have to be a matter of criminal justice.
Yeah.
You could have an inquisitorial system where basically a judge, limits the kinds of proof and decides what kind of witnesses to call, and streamlines,
I just
a
don't think that
process.
we've had this for 300-400 years. That's not the adversary system. Whether it should go away is a good question. It's not going away, but its excesses need to be curbed, and it is gone to excess. Or, like I said, you've got extremist advocacy, scorched earth defense, and judges have they have discretion. They can put guardrails on it. They can sanction
They do.
behavior, but it's too rarely exercised. Yeah.
I think that, and I think there's a lot of ideas that need to be thought about and considered, and so I hear yours with open ears, and you have a lifetime in litigation and in the law, so it also comes from a highly informed point of view. So I'd love to hear more about that going forward.
I mean, I think you're right. A wholesale change in the legal system probably isn't the case, but there may be opportunities in certain areas to, have a different kind of, procedure. I mean, for example, we talked about expert witnesses. Expert witnesses can go on back and forth forever. There's a procedure that started in Australia called hot tubbing, which doesn't involve water, where basically what you do is you let the experts question each other, which is a very interesting, produces some very interesting results, because you take away the expert's ability to confuse the lawyer who's asking the questions and is not an expert, and can probably get away with less when he's being questioned by another expert.
So two points about that. One is there is a rule that allows the court to appoint its own expert,
Sure.
which I think is rarely employed. But secondly, that's what we actually did in the Toms River case. We had a mediator, we had a scientific advisor to the mediator, and the experts would question each other.
They hot tubbed.
Well, I didn't.
Thank you. We have time for one more question, and then we're going to have a mingling session. We'd love for you to actually get a chance to talk one-on-one with some of the panelists, and we're serving also as well cookies and coffee. So last question, I think, for the day.
Sorry, thanks. I just have a quick question. I'd like to hear your thoughts about compliance. So like I've been involved in we won the class action.
Hey,
Now, how do you
congratulations.
get
Enforcing the classic.
How do you get the actual relief? Right?
Enforcement.
Like how do you
Yeah.
compel enforcement? And it's not, a big company will just not pay or stall, but it's a housing authority. Like the city, like everybody just abandons. And
Have the
then-
lawyers already been paid?
well, some, mostly, yeah. Well,
Harder if they've already been paid.
monitorship, a consent decree, and still we struggle for compliance, right? And it's about a public health emergency. So like, what are your thoughts on how to, like, the adversarialness of it proceeds through, through winning, right?
the
That
end,
doesn't
yeah.
fix it, yeah.
Thoughts, anyone? Francis, that sounds like another step in the civil litigation reform. You have to get to the end, and then you need enforcement.
Yeah, I mean,
As we all know, it's one thing to win a case. Then you have the trial for damages, which can be another long journey.
I want to leave a little time for mingling, so want to say thank you to all our panelists, our guests. We're so delighted to have had you here. Thank you.
thanks for having
And
us.
thank you to the audience.